What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today, returning intellectual property champion, is Stephen Burch. And I am so happy to have him on the show today, guys, because we're going to be talking about trademark. We're going to be talking about comic books. And I don't know enough about comic books in general. I haven't bought them in a very long time. I have no idea what Stephen knows about comic books, but I know he knows more than I do about intellectual property law in general. And so we're going to discuss trademark stuff. So they know me. Stephen, would you kind of give your people a primer on you?
I'm Stephen Burch. I'm a attorney at Smith and Associates. I deal with a lot of intellectual property issues, and I've been following this Fox Day issue since you brought it to my attention. It's pretty interesting.
Absolutely. So, just so anybody knows, just so everybody's aware, I should say, Stephen Burch is a practicing attorney in the intellectual property field. I am not. I do not do intellectual property stuff. So, if you have any intellectual property questions or issues, or you think you may need representation, we're going to put some contact information down for Stephen and his firm in the description of the video, and certainly check them out if you think you have a potential issue, because you in these types of things you need representation, and you need it from a competent attorney. That's why don't call me for intellectual property stuff, because that, again, it's outside of my scope. I talk about it, but I brought Stephen on because he knows the issues way better than I do. So speaking of the issues, if you're not aware and you're watching this video, I have no idea what you're doing here, but keep watching because this is interesting. But there is a movement in the comic book industry right now called ComicsGate. And a brief primer on ComicsGate is that they are opposed to the infusion of social justice into comics, into their chosen medium of expression and entertainment. They do not like what's been going on at big companies like Marvel and DC. So some comic artists have fractured off. Some people who did not have a chance to get into the industry have suddenly sprung up. We're talking about guys like Ethan Van Sciver being a former DC artist who is now independent. We're talking about guys like Diversity in Comics. You can check out his YouTube channel. I'll drop a link in the description to both of their channels. Diversity in Comics is a guy who was a critic of comics and is now a rather successful comic creator with Jawbreaker's Lost Souls, which is his first book. These guys and several others, Yellow Flash Comics. I'm gonna miss people because I don't even know who everybody is, but these guys have decided that they don't like how the industry is going. Their fans don't like how the industry is going, so they've created this movement. This movement is called ComicsGate. The origin of ComicsGate is a little nebulous to me, but as we'll get into here, the origin of it is not as important as some people think. But so these guys have been doing crowdfunding projects to fund their books, and recently another internet personality, I don't know if he's just an internet, a personality by the name of Vox Day, who you'll notice is wearing a helmet in my thumbnail. And the reason Vox Day is wearing a helmet is because this issue has been likened to the taking of a bike, so I thought a helmet was appropriate. That's why it's there, Vox. That's why. So Vox has come out in the past couple days. He has stated that he is creating a imprint for comics called ComicsGate. You can see it actually in below Steven in the bottom left of the screen. It says ComicsGate, which you can't see because I'm bad at technology, is the bottom of the mark, or the imprint says 100% SJW free, and it's got a CG in the middle there. Vox has claimed that this imprint will be available to artists who want to identify themselves as ComicsGate artists and help promote their book. This, of course, caused somewhat of a firestorm with the ComicsGate crowd, who did not consider Vox Day to be part of their community. They feel like he is maybe moving in to take advantage of this mark. Some people are saying it's a cash grab. Other people are saying it's sort of a secret op to take down ComicsGate, because they say anything Vox Day touches crumbles and falls apart. And Vox hasn't really revealed his intentions for it. What I can tell you is that from the outside, and this will talk to my personal bias, because I have been on Ethan Van Sciver's stream talking about this. He, of course, was on my show not long ago. So I'm a little partial to the ComicsGate movement in general. As for Vox, I don't really know much about him. I don't really care about him. I know some people say he's a white nationalist or alt-right or whatever. That is not something that I get into or identify with. I don't know. I don't know anything about it. So I'm not going to make those accusations. They're not part of this analysis. This analysis is literally based on, I talked to Ethan Van Sciver a couple days ago. Then Vox comes out with this thing, and a bunch of people are saying that it's either trademark or copyright infringement or something. Who owns this? And Vox says, I can own it because I want to. So that's the issue. And Stephen, does that sound kind of like what you are understanding? Did I miss anything important?
Only one thing I would add is when it comes to Ethan, it's not just necessarily the ComicsGate movement. Ethan has started a YouTube channel called ComicsGate Live, where he discusses these ComicsGate issues and different artists involved with the ComicsGate movement. So he has an actual product marketed under ComicsGate. It's not just that he's used the term before. He has a product that he's monetized, he's making money with. And I think that's an important distinction that'll come up as we talk more.
Right. And before anyone has a re-fest in the comments about that, Ethan's actual channel is Comics Artist Pro Secrets. And then he has a series of live stream videos that are heavily monetized because he does quite well with them through the super chat option. That is the ComicsGate Live series of videos that occur. I don't think those are the only videos on his channel. I don't think that really changes the analysis or anything like that. But he has, what's important to note is that he has a monetized series of videos directly related to the production and promotion of comics. On these videos, he has comics artists who are in the quote-unquote ComicsGate movement. They discuss things, and one of the activities that they do heavily on these videos is promote the crowdfunding campaigns. If you go watch most of the videos, I shouldn't say most of the videos. Many of the videos that I have watched, we'll use a lawyer speak there. Many of the videos that I have watched involve them actively monitoring their individual crowdfunding campaigns of the artists who are currently on the stream, talking about where they're at, asking the viewers to help them get across certain goal lines, meet this goalpost, meet this mark. Let's get them above $50,000 or whatever it might be. Almost like an old school telethon. They're promoting these products. They're also monetizing the chat. And I would assume the general viewership of these videos is monetized as well, but I don't actually know that. But we know that the chat is monetized and that Ethan makes a significant amount of money from this, and that all of the artists who have been promoted on the channel are doing pretty well on their crowdfunding campaigns and making certainly substantial amounts of money on them. And with that, I think that brings us to one thing we need to get out of the way right away. So we have non-lawyers talking about this issue on both sides. Ethan, the other ComicsGate guys, the fans, Vox and his Dark Legion or whatever they're called. All of these guys have been interchangeably using ideas of copyright and trademark. And that is very, very incorrect. And I'm going to let Stephen talk a little bit about this. But in the interest of time, you guys are going to just have to trust us. This is not a copyright issue at all. Copyright issues are created works of some sort of artistic expression. or intellectual expression or something. There's some sort of creative work of expression that you then receive a copyright in and can enforce against. ComicsGate is not that. ComicsGate, if anything, is a trademark, and so that changes the analysis dramatically. And I'm going to let Stephen explain what a trademark is and what some of the important things to understand about them are.
Great. To help understand as we move forward, a trademark is a source identifier. And so when you see, for example, a Nike swoosh, you know that it was made by Nike. And so Nike has a desire to keep that its own brand. They want to stop counterfeiters. They don't want people to associate the Nike swoosh with anyone other than that company. And consumers have, and that's the point of trademark law, is consumers should have the ability to know that when they purchase something that's associated with a brand, it actually associates with that company. And so overall, the general purpose of trademark law is for someone to be able to associate some sort of mark, whether it be a slogan, a name, a symbol, with a particular company, so that when they buy a product or they buy a service, they know that it goes to that company, not some counterfeiter, not someone else, not someone trying to eke in on someone else's brand. And that, in a nutshell, is the purpose of the trademark laws and a trademark in general.
And that gives the consumer other reassurances too, not just that their money is going to Nike, but that the quality that a company like Nike asserts that they're putting out is something that a customer can rely on and or find reprehensible, right? Like you can say, well, I want my sweatshop sneakers to be this good, and I know that Nike does that. And if the sneakers aren't that good, then you want to hold Nike accountable for making a subpar product. But if it's a counterfeiter coming in, they're causing damage to Nike. If someone thinks they're buying a Nike shoe and it turns out it was made by Reebok, which that would be a terrible, terrible thing. It turns out it was made by some other, some counterfeit company, and is of lower quality. That does damage to Nike's brand. And of course they might even get something like a fraudulent return, because there's all sorts of warranties of merchantability and stuff like that we won't get into here. But the consumer is protected in the way that they know to some extent what they're buying from a particular source. You know what you're getting into. One other thing I want you to talk about, Stephen, is the idea of, and we're going to talk about this. Maybe we should just roll this into Vox Day's video, because Vox makes some particular claims about what's going on here. And if I'm not mistaken, there are 4 specific claims that you've identified that we want to address. And is the first one registration?
It's not, but I think it's a good place to start.
Okay, so
in his video, he goes through and he claims that anyone who says that there's a trademark or copyright issue, and we're just going to stick to trademark here, needs to look up certain legal terms, and one of them was registration. And his point being that as far as I can tell and from what I've been able to see, there's no registered mark from Ethan with respect to ComicsGate. He hasn't registered his mark with the United States Patent and Trademark Office. The problem is that's not required. Trademark rights and your ability to protect your brand, they start as soon as you use a mark in commerce. As soon as you start using a mark to identify your good or service, and you use that in commerce, you have a protectable right, and you have the right to, assuming no one else has used it before you, and a lot of other caveats, you have the right to protect that brand and to exclude others from using that mark in a way that would cause a likelihood of consumer your mark. Registration is not a requirement at all. registration gives you certain benefits. It gives you protectability throughout the entire United States by default. It gives you certain statutory provisions, but the Lanham Act, the trademark statute, allows for federal claims using just what's called this common law mark, just this use in commerce mark. You have the right to bring claims in federal court if someone is essentially using a mark that would cause confusion with yours and causing you damage. So registration, while I would recommend anyone has a mark they're using in interstate commerce to register it with the USPTO, it's not a bar to bringing a claim, and it's certainly not a bar to preventing someone from infringing on your mark. Not even close.
Right. And two things I want to address. One of them is a product of my country bumpkin internet, but you glitched out when you said causing a likelihood of consumer confusion. And this is one of the big problem or the big issues in a trademark dispute, right? Because if you are making Lamborghini sandwiches versus Lamborghini cars, those are very different things. And outside of the, like particular branding. But if you're just some Italian guy with the last name of Lamborghini and you decide to make a Subway sandwich shop and you don't use like it's not like car themed or something like that, there's not going to be as much of a likelihood of consumer confusion because you're just going to a sandwich shop in whatever town this is. You're not going and buying a $400,000 automobile. There's some big differences here. So the likelihood of consumer confusion comes from a couple different things, and we're going to talk about that a little more later in the video. But I wanted to clarify that that's what you said because you glitched out, and that was, like I said, my internet is just wonderful. So that was probably that. And the other thing you mentioned, and I'm just heading this off, and maybe this is the next place to go. You mentioned as long as no one's used it before. So somebody out there undoubtedly is thinking, well, ComicsGate wasn't first used by Ethan Van Sciver. It was actually used by so-and-so or applied to this person or someone else coined the phrase. And that's not what we're talking about here. So I think another one of those points was prior use, right?
Correct. Prior use.
And if you want to talk about that in reference to trademark, I think would be very helpful.
Definitely. Prior use, again, and it ties back into the likelihood of consumer confusion, which you touched on, but it's the keystone to any trademark issue, which is, again, if the point of a trademark is to allow consumers to identify the source of their goods or service, if you're infringing on that, you're causing some sort of consumer confusion. So courts always look in any trademark cases, is this other mark causing a likelihood of consumer confusion? And so when they do that, when they look at your mark, they want to see, is the mark that's in dispute, was it used before? Is it a prior user? Was it a senior user, or did it come after? And one of the points that Vox Day brought up is, ComicsGate has been around long before, this, and I apologize, it's not the channel, but it's, the series on the channel. It's been used before, so he doesn't have a claim, is what, as I understand it, what Vox Day is saying. But that's not necessarily the case. Just because a slogan has been around for some point, it doesn't mean that it's been used as a trademark or as some sort of source identifier. And that's what's at issue here. The slogans have been around. There's lots of examples of slogans or general words or descriptive, generic words that have been around for a long time, and then somebody has taken the initiative to say, I'm going to take this slogan or this term and I'm going to apply it to a specific set of goods or services. And that's where the trademark analysis starts. It doesn't start with just this generic use. If it's not tied to a goods or service, it's not it's not a trademark. It's only when Ethan starts using it in conjunction with his YouTube series that's where we look at. And so I don't know for sure. I'm not an expert on the facts, but as far as I can tell, this is the first use in commerce. This is the first use in conjunction with some sort of service or good of the ComicsGate mark. And so that's where the prior use is going to come in. And it doesn't appear from the facts that I know that there's any prior use. The idea that they've just, someone has used it, that it's been a hashtag or something like that on Twitter, that's not, that's not a prior use, at least as, you know, when it comes to some sort of likelihood of confusion or trademark infringement now. And so his idea, of, hey, you need to look at prior use. Well, as far as I can tell, I've looked at prior use, and it doesn't seem to be an issue. So.
you may have seen it once or twice.
Right.
Yeah, and that's the trick, guys. And you've seen these slogans before. Something we've talked about. You mentioned Nike earlier. People said "just do it" before Nike trademarked the slogan "just do it." People said "race for the cure" before Susan G. Komen Foundation decided to trademark the term "race for the cure." But now, if you run a race or a walk or some sort of event where you're fundraising money and you say "race for the cure," people are automatically going to assume that that's in reference to like a Susan G. Komen Foundation. And they are, by the way, they're about as bad as Disney in defending that trademark. They defend it vigorously and often, and a comical amount of legal fees get paid annually defending that trademark. So these slogans can be around, but it really matters when they entered the stream of commerce. That's when and were associated with a particular good or service. In this case, and I will firmly admit that my knowledge of this is limited. Some of you out there are going to be much more versed in the lore behind all this than either of us. But my understanding is that Ethan's channel, ComicsGate Live, is the first, or his show on his channel. I want to be precise. His show on his channel, right, yeah. ComicsGate Live, is the first commercial use, the first monetized use in association with anything that would be related here. That may not be true, and if you know of some other commercial use, please put it in the comments, and that might lead to some sort of corrective video or whatever where we could talk about that prior use. But as far as I've seen, that's the first monetized use, and as far as I know, actually Vox Day's imprint would be only the second use that I've seen of it going into commerce, because a lot of these guys who associate themselves with ComicsGate are sure they're crowdfunding stuff and they go on Ethan's show, but they're not actually putting ComicsGate as like a slogan or a mark or an imprint or anything like that on any of their products. They might say that there might be a hashtag ComicsGate somewhere in the description of the Indiegogo, but we're and I don't know if that's true, but we're talking about their actual marketing of their product does not involve that mark. It's Cyberfrog by Ethan Van Sciver. It's Jawbreaker's Lost Souls by Diversity in Comics, or maybe it's under his legal name. I don't know, but that's what's being sold here, and that's kind of the difference. Vox is proposing to use this ComicsGate imprint on the comics. In fact, he has stated that he's using it on the first issue of Gun Ghoul, the first print issue, which I think has a crowdfunding campaign going right now. And he has a mock-up of the front cover, and the little imprint is on the top left corner. So that, as far as I know, is only the second commercial use, which might lead to the third point that you have, which I think is dilution, right?
Correct.
Can you explain that?
And well, in his video, Vox Day asserts that Ethan needs to look at dilution as a reason why he doesn't have a claim. Looking at it that way, and just by the way, dilution is I don't want to get into too off topic, but dilution just means that you use a mark so much that it becomes a generic term. I'm trying to think. There's some good examples. Aspirin used to be a brand name, but then everybody just called acetaminophen aspirin, and next thing you know, that it lost any protectability because it became generic.
Right. Xerox, Kleenex.
And so trampoline.
Right.
Yeah, there's a lot of examples where it happens, and so brands need to be careful to not allow their term to just become generic.
Just realized I had a Nike shirt on.
So that's what dilution is. And so I think, yeah, I'm a little confused as to exactly what Vox Day is trying to assert here, but I think his overall idea is that this term's been around a lot, everyone uses it, and so you don't get to have any claim over it. And I think it goes back to, kind of the same prior use analysis, and that is it's not been diluted with regards to the services or the goods that Ethan's providing, which is his YouTube series. No one's used ComicsGate, at least as far as I know, for that type of service before. It's completely new, and I don't think that dilution, at least legally, is an issue that Ethan needs to worry about. On the contrary, the way that you prevent dilution of a mark is by preventing other people from using your mark for goods and services that are similar to yours. And so, to the extent that dilution is an issue, it would be an issue for Ethan to look at, to say, hey, if I have this mark, I'm using it. If I let Vox Day and someone else or whoever continue to use their mark to promote goods and services that are similar to mine, my mark's going to start being diluted. So he may need to take action to stop that. But looking backwards, I don't think the protectability or the strength of Ethan's mark has been diluted at all. It seems like he's, as far as I know, the first person to use it. And, this Vox Day issue seems to be the first, infringing or close to infringing or potentially infringing use to come afterwards.
So, kind of going along that, but in a little different way, and right before we get to the fourth point in the video, I want to talk about something we talked about in our last chat, which was the idea of someone trademark trolling, basically. Should Ethan be concerned that Vox would do a hostile takeover of ComicsGate and then assert that Ethan's channel or that future releases of ComicsGate associated artists would be infringing on his mark if Ethan allows him to use this ComicsGate imprint, for example, and doesn't fight it, and then Vox comes out maybe 6 months down the road after they published 5 or 6 books, and says, you know what, anybody using the ComicsGate mark to promote their book is now infringing on my mark. Is that something that Ethan or these other guys should be worried about?
To an extent. So, in any trademark analysis, you look at priority, and it doesn't matter if Vox eventually gets a federally registered mark, or he gets a registered mark in Europe or anything like that. If Ethan was using it first, he has priority. There's a famous example of a guy he had a McDonald's restaurant in, I want to say, Illinois. And then McDonald's comes around and they try to start building their restaurant there, and this guy was able to exclude them from his entire county because he had his restaurant first. However, if you only have a common law mark, you need to start being able to prove where your area is. Your common law mark is only valid in the area where you use it. And so, where is that area? With the internet, it's hard to define. Where are all your users? Where is your market? Where is your and so there's a concern that if someone were to get some sort of registered mark, they may have a territory that is outside the scope of your common law territory,
Sure.
and they would be able to exclude you. And then there's just the practical realities of if someone serves you with a trademark infringement lawsuit, you need to hire an attorney and you need to put down a deposit. You need to defend yourself, and someone with a registered mark is in a good position to make that assertion, and you're on the defensive at that point. It's not a good position to be in.
Right. All right, so the last point in the video. Do you want to talk about that one?
This was my favorite part of the video. At some point, he says, he could make a movie called Star Wars, and and I'm paraphrasing, there's nothing anyone could do about it. I would not want to be the attorney defending the guy who created a movie called Star Wars today. Unless you had a license from Disney, you're looking at a host of really expensive lawyers breathing down your neck. But that said, this comes from an idea. It's not like he's making this up out of thin air. There's this idea. It's not an idea. It's a codified trademark issue where you don't have trademark rights to the title of a single creative work. It comes from there's a lot of First Amendment issues where you don't want trademark law to stop creative processes. You don't want people to not be able to speak, to create, to move things. And where this comes up a lot is songs, for example. You can have the same name for a song for multiple artists, different songs. I looked up an example I knew, and Beck, Grateful Dead, and Three Doors Down all have a song called Loser. None of them can stop each other from asserting that because it's just a single word. However, that's the exception. Once you get past a single work and you have a collection of works where you're using the same title or a similar title for multiple different creative works, think Star Wars 4, 5, and 6. They have the same name, but they're completely different works. I mean, I can't count the number of Star Wars movies there are. Most of them are good, not all of them, but they are individual works, and they have and I've looked it up. I believe you have too. You can go to the USPTO. They have registered marks, and they are protected, and it's for the title of the movie. And it is very easy to create and protect a mark for a series of creative works.
And guys, when he says they have registered marks, they have registered marks for days. Just page after page after page of just Star Wars. Like, not even Star Wars The Phantom Menace, Star Wars Attack of the Clones. Certainly those are in there. But honestly, just Star Wars. And when you check out the individual mark, it'll say like Star Wars, and then it'll have a subtitle because it might be one of their books or their comics or their graphics novels or their toys or their Lego licensed products or something. They just have pages and pages and pages. And the idea, the reason this is a funny thing is because is not because Vox Day is wrong about it. Like, that's not what's funny. What's funny is that Vox is asserting, and this is something that I see a lot as an attorney. I'm sure Stephen sees it a lot. And other professions, you see it all the time. Someone saying These guys aren't attorneys referring to ComicsGate and their fans. They don't know anything, but neither is Vox Day. And that's pretty evident in his analysis throughout this whole thing. And that's why we're bringing it up, is because this is a basic error of trademark law to assert that you could go up against a Disney, who is one of the most litigious companies on earth, in regards to protecting its intellectual property. You could go up against them in making one of the most notable franchises in history, a movie titled in the same way within that universe, and get away with it. If Disney could have done that without paying $4.5 billion to George Lucas, they likely would have done something less expensive, right? They may not have just outright infringed, but that price tag would have dropped by a significant amount if they could have just made a Star Wars movie. And you know, that doesn't work that way. And I want to be clear, like, the idea that you could make a movie titled Star Wars is not just saying that you can't make a movie within the Star Wars universe titled Star Wars. You would be hard pressed to make anything that is a motion picture of any kind titled Star Wars, because their trade line is motion pictures in regards to these marks. You know, they have other marks for toys and stuff like that. Their trade line is not motion pictures that exist within George Lucas's created universe that involve lightsabers and Death Stars. Okay? If someone's going to a movie theater and they see a big thing that says Star Wars, they're going to walk into that movie expecting to see something like Star Wars. And if they see some sort of drama about, like, Neil deGrasse Tyson arguing about the validity of a constellation, that would still very likely be an infringing trademark, even though it has nothing to do with the Star Wars copyright. Again, we're talking two different things here. So the reason we're bringing that up is because this is the difference between people who have read about the law and people who kind of live in the world of legal expertise. And in just the same way that I wouldn't try to tell Vox how to blog about weird stuff, he shouldn't be telling people what legal realities are when it appears that he's not aware of some of these basic things. But with that, I think that kind of closes out the video issue. The next issue that we have to talk about, and this video is going way longer than I planned, and that's fine. but stick with us, guys, because this is how we're going to go through something called the Dupont Factors. Dupont being a landmark case in trademark law. I'm not going to read the case name because I don't want to, but basically it's this list of factors that, well, actually, I'm going to have the expert describe it. You talk about the Dupont factors.
So, I've mentioned it before. In any trademark case, the issue is there going to be a likelihood of consumer? If you're talking trademarks, that's the standard. Is there a likelihood of consumer? And if you're a court, you need to be able to have some sort of test. You don't know all the things. You don't know. You weren't there from the beginning. You need to have.
Let me interject one thing, because this is important to know, guys. I know some of you are out there thinking right now, these guys don't know about comics, or they're not familiar with the entire story of ComicsGate, or they don't know about this one guy who did something. Let me tell you right now, the chances of you getting a comics superfan or a ComicsGate follower as a judge, or in the case of the Patent Trademark Office, you've got a board of basically attorneys who decide these issues. The idea that you're going to get someone who's a massive fan of comics as that is following this particular issue to the extent that you as a fan are, is very, very unlikely. In any sort of specialized hobby sort of thing, or even in major pop culture, because you gotta look at the profile of who is filling these positions. They tend to be older. They tend to be very upper middle class to upper class. They tend to not necessarily be into quote unquote nerd culture, and they tend to be very behind on things like technology. Just as kind of a general rule, think of your grandpa when you think of the guy who's deciding these issues. So while Stephen and I may not be experts on ComicsGate, the judge that or the patent trademark board, or the judge, if you bring this in district court, who's going to be looking at this case, probably knows even less about it than us, and they're going to be relying on the attorneys from both sides to give them facts, and then they're going to bring in a jury of people who know nothing about it, and those people are going to decide what facts matter. So you're not going to have a lore expert on your movement deciding these things, and that's why we're talking about the Dupont factors here, because this is how a court looks at these issues. They don't look at them as a super fan. They look at them as a court who pretty much doesn't know about it. So I'm sorry to interrupt, but
No.
I wanted to clarify that before someone says, well, but what about this person? So, okay. Sorry,
No, and I think that's important, because that's what the test is there for. The test is there so that a judge or a jury can say, is there going to be a likelihood of confusion? How do I determine if a reasonable consumer would be confused between this mark and the new mark? And there's 13 factors. Although I will tell you, just to skip to the end, the 13th factor is any other established fact probative of the effective use. So it's this expansive scope, but a court, and I also want to focus, the court can look at any number of factors. Some are more important than others. One that's always going to be important is the first factor, which is the similarities between the marks. And so you're going to look, is the name or the words here, or the symbol, is how closely does it resemble the other symbol? And here, looking at that, it's the exact same. ComicsGate. They're extremely similar. So the first factor weighs heavily in favor of Ethan. The next factor, which is also another factor that's almost always highly probative, is the similarity of the goods or services. And here, they're not exactly the same. As I understand it, you've got one which is a YouTube series which discusses comic books, and the other one from Vox Day, which is a series of actual comic books. So there's a slight difference, but they're pretty similar. I mean, you could see someone who has a series about comic books actually producing comic books. I mean, you could see how a consumer could confuse those and think that they're the same source identified.
Right, and briefly, one thing that, if you're Ethan Van Sciver's attorney, and you're arguing this issue in court, and that this sometimes is kind of a good thing for people to understand, the argument that you make is that, look, my client, of course, yes, ComicsGate Live is his YouTube channel. On this YouTube channel, they talk about the creation of comics. They talk about promoting the comics of the creators who are involved. Ethan Van Sciver promotes his own comics on this channel, and so anyone who goes out and sees a ComicsGate stamp of approval is going to be associating that imprint with Ethan Van Sciver's show, which is promoting these comics. That's the argument you make. If you're Vox Day's attorney, you make a completely different argument. You say, no. There's no marker imprint on a comic book marketed by Ethan Van Sciver that says ComicsGate. That doesn't exist. His Indiegogo page, I don't know if this is true, but you'd say his Indiegogo page doesn't have ComicsGate referenced, or it's not prominently referenced. It's not part of his branding and marketing. He's Ethan Van Sciver. He doesn't even need the ComicsGate thing. That's just a YouTube show that he does, and it's unrelated to there. And so then the judge is going to take those two arguments, or a jury is going to take those two arguments, and they're going to weigh them against each other, and they're going to determine what a reasonable person, and most likely they're the reasonable person in this situation because they are not the comic books fan. They are not the ComicsGate follower. They are not the Vox Day fan. They're just your average Joe. And they're going to say, look, if this guy has been promoting stuff under this ComicsGate thing, and I walk into a store and I see this imprint that says ComicsGate 100% SJW free, am I going to think it's from him? That's the analysis that's going to take place for the fact finder, be it a judge, a jury, or the Patent Trademark Office board. And so that's what's important to remember here. Not how you're thinking about this, or how Vox, or how Ethan thinks about this, but how your average person on the street who probably hasn't bought a comic book maybe ever, and probably not in the past 12 months, is going to think about this. So sorry to...
No, and I'll skip ahead. I'll skip past trademark, but I believe that the conditions which and buyers to whom sales are made. And what that means, if you look at the case law analyzing that, is are these sophisticated buyers? If you're buying a Porsche or a Ferrari, you probably spend a lot more time investigating the details than if you're buying a $5 comic book. Or I actually don't know how comic books cost. They don't cost as much as Ferraris, I don't think, unless they're really old or something. But and so you're dealing with just the average consumer on the street who's probably not doing a lot of background research. And so with that, the scope of infringement's bigger. You're not going to have these sophisticated consumers who have done a lot of research, which goes in favor of Ethan against Vox because they're close. The names are the same. They're not exactly the same goods or services, but the consumers are hearing the same words, the same tones, the same name. And that's what the court's going to be looking at with that. And backing up, the other one is the similarity or dissimilarity of the trade channels. And what that means is, how is this sold? And barring anything else, they're sold just through the normal way that goods are sold, normal trade channels. They're available on the internet, they're in stores. It's not like this special thing where you have to go through some wholesaler to buy it or through some, this is available to the public. And so here you've got general public. They're not, sophisticated buyers. You've got the same name. You've got very similar goods and services. So the first four, which are very important factors, all weigh in favor of Ethan. At least according, at least in my opinion. And I don't want to go through all of these because not all of them make sense to this, and a court won't either. The court will look at each of these factors and say which ones make sense to the situation.
Here, I'm gonna speed read through them though, so that everybody knows.
That.
I'll read 1 through 13. Here, we've talked about the first 4, but I'm going to reread them so you just know what type of factors there are, but we're not going to do an analysis on each one here. So, number 1, the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. Number 2, the similarity or dissimilarity and nature of the goods described in an application or registration or in connection with which a prior mark is in use. Number 3, the similarity or dissimilarity of established likely to continue trade channels. Number 4, the conditions under which buyers to whom sales are made, i.e. impulse versus careful, sophisticated purchasing. And I have this as a separate list probably from what you're looking at, but it might have a little commentary to it. So number 5, the fame of the prior mark. Number 6, the number and nature of similar marks in use on similar goods. Number 7, the nature and extent of any actual confusion. Number 8, the length of time during and the conditions under which there has been concurrent use without evidence or actual confusion. Number 9, the variety of goods on which a mark is or is not used. Number 10, the market interference between the applicant and the owner of a prior mark. Number 11, the extent to which applicant has a right to exclude others from use of its mark on its goods. Number 12, the extent of potential confusion. And number 13, any other established fact probative of the effect of use. And if you don't know, probative is a legal term which means something that makes a particular fact more likely to be true. That's what probative basically mean, probative value. It's a standard of it's part of the standards of evidence. But so any other established fact that makes the facts about use more likely to be true can be considered by the court, is what they're saying there. But those are the 13 Dupont factors. As Stephen said, a court's not going to consider all of them because not all of them are going to apply. Like, for example, the variety of goods on which a mark is or is not used. It's probably not super relevant here. The actual confusion is probably not relevant yet because we don't really have a lot of history with these two marks. I mean, Ethan Van Sciver's show has been going since something like January. But Vox Day's mark is brand new. So there's, and I don't think his mark has actually been released on the new issue of Gun Ghoul. I don't think that that has actually been printed yet. So right now there's not much opportunity for an actual confusion to take place. So the court probably is going to ignore that factor and talk about the potential for confusion. But so there's the 13 things. Go ahead. Sorry.
Oh, one thing I will say, the actual confusion, while it's not necessarily in play now, just in general, actual confusion, if you can get emails or something along that line to support that consumers are actually confused, it's not necessarily a home run, but it is one of the best factors to get. So if one side can show that their consumers are confused by the mark, you have a very, very good chance of proving infringement.
So there you go. If anybody mistakenly buys Gun Ghoul thinking that it's an Ethan Van Sciver promoted product, that would be evidence of actual confusion. And if they communicated that to someone, that would be evidence that the court would probably consider in that case. So since we've got past the Dupont factors, there were 4 comments that we went through Vox's blog post because he still has a blog, and that's cool. I don't know what kind of traffic his blog gets or anything. I assume quite a bit. Actually, because Vox has been a prominent sort of figure in certain circles for a while. He's a video game developer and stuff like that. So I just think it's funny that he has a blog because I didn't know people still wrote them. And so that's cool. I wish I had one. Except I don't want to write things. But we've identified 4 comments that Vox made, and you can go read his blog. Was basically just a repost of some of the questions from his Bounding into Comics interview. We're not going to go through that, but in the comments we have 4 numbered comments that are by Vox Day. We're not going to go through all of the weird legal stuff that's claimed by any of the other people commenting, because that would take all day, and we don't have enough liquor on our shelves to get through that sort of thing. But starting with number 18. So I think I should read the comment and then you can discuss. And then if there's anything for me to add, I'll do that if that sounds good with you. So comment number 18, he's quoting someone saying, Ethan Van Sciver will fight Vox in court. It's clearly copyright infringement. And then Vox says someone doesn't know much about copyright law. So,
well, I mean,
thoughts?
Here, Vox is right. It's not copyright infringement, at least, from what I can tell. There's no copyright issue. To the extent there's an issue, it would be a trademark issue. So, score 1 for Vox here.
Good job, Vox. Now, we say good job now, but we're moving on to comment number 69. And this is Vox responding to this comment. Some other person said, I don't know much either, but he did say in the stream, he being Ethan Van Sciver, did say in the stream that he named his show after a term that was already floating around. And Vox's response was, for a lot longer than any of these morons grasp. So we just gave Vox a props for copyright, saying that someone didn't know anything about copyright law. But do you want to talk about this comment?
Well, let's assume he's right, and I believe he is. The term's been floating around for a while. We talked about it. It doesn't affect the trademark analysis, though. It doesn't affect any infringement or that type of analysis, because the issue is, was it being associated with goods or services before or not? And as far as I can tell, and as far as I've been able to research, Ethan's was the first to say, no, it's not just a term, it's not just a slogan, it's a mark that identifies my service. And so the idea that the term's been floating around for a while, it's irrelevant to the issues that we're talking about.
And the reason I was trying to link it not so subtly to comment number 18 is because it would really matter quite a bit if we were talking in terms of copyright. If we were talking about copyright and a created work that someone had made years prior, and then Ethan Van Sciver came up and took that created work, and ignoring like fair use analysis and all that stuff. But if he just took that created work and started using it, that would be copyright infringement, and it would really matter how long the use had been around. That would be very relevant. So I think maybe Vox is asserting that other people don't know about copyright, and he may be a tiny bit confused about what even is a copyright. But I don't know for sure. Vox is purportedly a very smart guy. If you didn't know this, I did a little research on him. He's a former Mensa member, so he is recognized by Mensa as being at least above average intelligence. I don't know what their requirements are, but what was that?
Higher than something I could meet. So I mean, good for that.
Oh, don't sell yourself short. I think you might give Vox Day a run for his money. Absolutely. All right, so number 78. Someone asks, so is Ethan infringing in Vox Day's intellectual property? Vox Day says, no, of course not. Look, none of these guys knows the first thing about copyright law. And again, he's talking about copyright here. My guy has been an expert in it for 30 years. We successfully dealt with the NBA and the Golden State Warriors on a similar matter 25 years ago. This is literally nothing. And I think what stood out most to me was, one, his claim on the expertise of his quote unquote guy, and then the statement, this is literally nothing. Because this might actually be something. Saying this is literally nothing is kind of a big stretch there. And then personally, I don't put a ton of stock in the length of expertise of an attorney. Sure, someone who's successfully practicing law for many years is presumably good at it. But whether or not you have a legal claim doesn't really depend on how long your attorney's been practicing law. It's whether or not you have a valid legal claim. But did you want to say anything about this? Maybe, I don't know, about the Golden State Warriors or anything like that?
Yeah, I guess the problem I had, I tried to do some research, and it was cursory. I don't want to, mislead anyone, but I couldn't find exactly what he was talking about. So I don't know the details, but I would imagine it has to do with a book he wrote or work he did entitled Warriors, and some sort of trademark claim with the Golden State Warriors. And they would have to go through those same Dupont factors. But as you go through those Dupont factors, you're going to come up with different analysis, especially when you get to the goods and services. And so I don't think that just because in one instance with completely different facts and a completely different underpinning, you came to one result, it doesn't necessarily correlate to, here are these sets of facts, what are the results? They're not going to end up being the same. And I don't know all of the facts with the NBA and his other issues, but I doubt they're the same, and I doubt that they're going to lead to the same results as something a quarter century ago.
Now, and I looked as well, again, a cursory search. So if you guys can find this info, please put it in the comments. You know, I'm happy to look into this stuff. I could not find anything about Vox Day and the Golden State Warriors 25 years ago, but as a hypothetical, I looked at Vox Day on his live stream, and I'm pretty sure he is not forming a basketball team to compete with the Golden State Warriors in the NBA. I'm pretty sure. I'm pretty sure he's not sufficiently wealthy to independently create a basketball team and inject himself into the NBA, or to create a separate league to compete with them. And I don't think he's playing basketball because he looks like he lacks some of the physical characteristics required, like height and muscle tone and all that stuff. Maybe he's super shredded under his shirt. I don't know. But I don't think he's entering the field of basketball. And while his head sort of resembles a basketball, I don't think he was like tattooing. It's not a comment on your head, it's a comment on his head. No, but I don't think he was tattooing like Golden State Warriors or something on his head and then trying to sell his head in advertisements or something. Like, so we gotta, what Stephen was talking about is the similarity of the goods. I don't know the details, but I have a hard time believing that his details are at all related to the NBA or basketball. What that does not preclude a giant corporation like the NBA, or even a giant corporation like an individual team. I mean, these teams are valued at, sometimes $1 billion, depending on who's on them, or hundreds of millions of dollars. These are large corporations, these individual basketball teams with hundreds of people on staff and stuff like that. They're much bigger than just the guys on the court. So you've got these multi-$100 million at a minimum organization like the Golden State Warriors. You've got a guy like Vox Day who they see as an individual. He puts out something that they feel might come close to maybe infringing on their trademark, and they send him a cease and desist letter, because they do this a lot. Big companies do this all the time. Try and make a mom and pop store that called Best Buy, or something like that. Best Buy sandwiches or whatever. It doesn't matter. Try and do it, and you'll get a letter pretty quickly as soon as they find out. Because they have an interest in enforcing their mark, because as Vox mentioned, dilution. That doesn't mean that they have a good claim. And a lot of times, if someone has the resources to fight back against something like that, they can get that big corporation to shut their mouths really quickly. A competent attorney drafting a response to that can say, look, you got no case here. We're doing this. You're doing basketball. They're completely unrelated. We're going to blow you out of the water, and you'll have to pay our attorney's fees, and you're going to waste everybody's time. It's going to be bad press. What are you talking about? Just go away. And you can head off some of these things at the pass. So whatever happened between Vox and the Golden State Warriors remains a mystery. But you can come up with a lot of hypothetical situations in where Golden State probably didn't have a claim. Vox mounted some sort of successful defense. It all happened out of court, it seems, because there doesn't seem to be any easy way to find any information about it. And that's that. Vox, you're welcome to come tell me what happened, by the way. I honestly don't know. But you can think of very few hypothetical situations where Vox Day was competing in a similar trade line to the Golden State Warriors. So I want to make that very clear. Did you have anything else to say on this one? I got the one last comment
to get to. I think you covered everything.
Okay. So the last comment here is 142, and bear with me, this is a little longer. So Vox is responding to someone saying, I'm reaching back quite a ways to my entertainment law courses, but EVS may indeed have a case for trademark infringement. I tend to agree with this commenter that he might have a case. But Vox says, certainly, if someone started a YouTube channel called Comics Artist Pro Secrets, But to try to retroactively claim a trademark for something that is not the name of your channel that many others have used, that only happens to use some of the words and is not a streaming channel, is not even remotely credible. Let's stop there, and I'll have you respond to that.
No.
That might be enough, but please explain.
So again, it's, you know, they have some separate words after, but ComicsGate is the key portion of both marks. So that's a big, you know, again, they're factors, and you look at the factors, and that's the first one. So the idea that they're not exactly the same is, you know, it's not this positive, and the fact that they're very similar and contain many of the same words is not a factor in favor of Vox. The idea that it's not just a streaming channel, again, it doesn't have to be the exact same goods or services. It has to be similar enough that the reasonable consumer would assume that they're related. And here we've got people talking about comic books and comic books. I think there's a very strong argument that could be made by a competent attorney that those are similar goods and services enough that a reasonable consumer would be confused.
I think an incompetent attorney might be able to make a pretty good argument about it.
Exactly. Yeah, just monkeys could throw something and come up with an argument that it's there. You know, so to say that it's not remotely credible, I mean, does it eventually win the day? I mean, you know, judges do what judges do, but it's definitely credible. I would, you know, if I were advising a client, I would certainly warn them that what you're doing has the potential for litigation, and litigation that may not be favorable to you. So the idea that it's not remote seems like a stretch.
Right. And I want to point out a couple things. Not the name of your channel has no impact on this at all. Or I shouldn't say no, but extremely, extremely limited impact. Think again, if you made a clothing line that sold athletic wear that said just do it, Nike would, I mean, they'd take your house. Not really, but they might take your children and put them in a shop.
And I think Nike's a great example. Nike is, you know, Nike Inc. Just do it. It's not the name of the corporation. The idea that it needs to match. It's a mark. It's a mark that he uses to identify the service. The idea that it's not the name of his channel, and I missed that, is when I was talking originally. But it's completely irrelevant to the analysis.
Right, because if nothing else, it's identifying a series of works, and that is the live stream videos that he does called ComicsGate Live. Like that series of works can trademark, you can trademark a mark for a subset of products that your company produces. If you think of Apple has a trademark on iPhone, even though iPhone is not the name of a company. I don't think iPhone is, it might be the name of a subsidiary, but I don't think so. But even if it is, the airport base station is not the name of a subsidiary, and any other number of Apple products that will have trademarks on them, or any number of slogans. They don't have to be the name of a channel, the name of a company, or anything like that. They're associated with a series of works, and that is more than enough to earn a trademark protection in this case. So not even remotely credible is probably poor analysis by Vox Day. He follows up with, we beat the Golden State Warriors over the use of the term Warriors, which is, by the way, a completely, like that alone, not knowing any other context, makes this a completely different analysis, because Warriors is a word that is used extremely commonly. It is not anywhere near as unique as something like ComicsGate. ComicsGate is, there's not like a gate made out of comics that is in that people will run across on their average day and use this word frequently. Warriors is something that it has been used in multiple contexts, in multiple trademarks, in multiple instances across the entire history of the trademark system. So using the term warriors is going to get, we didn't talk about this really, but having a distinctive mark versus a less distinctive mark is very important. Golden State Warriors is a very distinctive mark. Some other thing using the term warriors is not. And so that analysis alone is going to change this dramatically. It's going to make it not, I would say, very, very incompatible with a ComicsGate style analysis. So I want to point that out. And then he says, there's absolutely no way Ethan or anyone else will ever get a trademark for ComicsGate alone because dilution and prior usage. And I will say that is, you're smiling and chuckling and trying to hold back the laughter. But that seems to me, and I'll defer to you, the expert, but that seems to me to be poor analysis.
Of course it is. I right now, I could start a whiskey brand, which sounds like a good idea over being an attorney, and I could call it ComicsGate Whiskey. And I promise you, barring someone else already taking that idea, I could get a trademark for it. And I would argue that barring anyone else using that mark for for that type of YouTube video service, he could get a mark for that as well. And I believe he could get it registered. And again, I don't want to, sometimes it gets mixed up, but him using it, he has a mark. He has it. He's using it. It's a protectable mark. The registration, which I believe is what he's talking about when he says get a trademark. I believe he's talking about register it with USPTO. I would need to do additional research, but he most likely could register it with USPTO.
Based on the facts that we know, let's walk people through this. My understanding would be based on the facts that we know alone. So Ethan being the purported first trade use of this for his YouTube channel. Ethan goes to the USPTO, grabs the forms, fills it out, puts in the appropriate categories and pays his fee and says, I want to register ComicsGate as a trademark for YouTube channel, print media promotions, and whatever. I don't know the specific categories, but there's something similar to those, and podcast or whatever. Podcast or other recorded works. So he fills out the form, does that, submits it to USPTO. No one opposes the mark. Ethan's going to get a registered trademark, right? Right. That's going to happen pretty much guaranteed.
So the examiner will do, so before it goes to opposition, the examiner will do two things. He'll do a distinctiveness analysis to make sure it's not generic or merely descriptive. And he'll also, or she, will also do a search through the USPTO database to ensure that it's not going to cause a likelihood of confusion with an existing mark. If it passes both of those tests, the examiner's happy. It gets published, and anybody can oppose. But then the opposer has a burden of proof to show that they're a prior user and it would cause damage to them, that they would be harmed. And again, based off of what we know, I don't know anyone who was using this mark in service prior to Ethan who could show any damage, because there's no one who's using it in commerce, prior to him. And so an opposer would have a hard time. And again, whether there's an opposition or if there's no opposition, I could see the mark, eventually being registered.
Yeah, and I'll point out, I did a very basic search for ComicsGate, ComicsSpaceGate, and ComicGate on the USPTO. There's nothing. There's no entries. There's nothing that's going to be similar to those particular things. It would start to get really weird in how you would have to connect them. I'm not sure what a the patent trademark office analyst would find. Maybe that would be in some sort of conflict, but this is a pretty distinctive mark. It's certainly not a generic mark, and I would say it's strongly distinctive, and there's no registrations for it in any trade lines that I could find, and there's nothing particularly close that was easy to come up with. So, I mean, the idea, guys, if he pays the fees and no one opposes him, he's gonna get the trademark. Like, I'll say that with confidence. It would be shocking. It would be shocking for him to not get the trademark. There would have to be something no one has thought about that only the Patent Trademark Office in their infinite wisdom would be able to see at a cursory glance here. I would be blown away. Now, the fact that someone might oppose him, I don't know who that would be. If it would be Vox, based on what I've seen, Vox loses, and Ethan gets the mark anyway. Unless there's someone else with a prior use, like you're saying, that would be the way. But there's certainly a way, and dilution and prior usage, outside of seeing someone using it in trade, I don't think Vox is right at all in this claim.
And I just want to point out, because I get his point, but I think it's important for everyone to understand, with or without a registration, you can have a protectable, forcible interest that you can go in front of either a state, or if you can make the right claim, and usually you can, a federal court judge to enforce regardless of a registration. And I think that's important, because I don't think a lot of people understand that. That's not the same with, say, patents or copyrights, because to enforce a copyright, you need to at least get a registration beforehand. You do not have to get the registration before you enforce your trademark.
Right. And real briefly, you mentioned earlier that there might be a specific area, but with Ethan, he has a big advantage that his market is an online market on YouTube that reaches something like, I think his subscriber count, which is a strong argument for your market, is something like 75,000 people. And I'm going to wager that covers a huge swath of the United States, just based on the way these things distribute out. He's going to have a pretty good claim to have protection in pretty much it's certainly in any major market in the United States, and probably across almost all of it. Maybe not in Montana.
But it's enough that it matters. It's enough that you can get a judge, you can get a federal judge to issue an injunction to prevent any other use. It's substantial.
Right. And okay, and there's one last comment that we want to address. He's responding to someone who says he has over $500,000 from his Cyberfrog fundraiser. It must be burning a hole in his pocket. I'm sure he can find a lawyer who would like to help himself to it. I would love to, Ethan, but I can't. I'll take all your money. No, I'm just kidding. I actually can't represent you. He could. No question. So this is Vox's response. No question. I mean, I think that there is a question, but and over here in Europe, he'll end up paying for our lawyers too. That would be the most ironic outcome. We end up owning Cyberfrog. I mean, this is just another one of those things. I'm pretty sure that Ethan, unless he was pursuing a European trademark, wouldn't have anything to do with the European courts, but feel free to chime in on that one.
To the first part, yes, there are attorneys who will take your money. Me being one of them, there are lots of them. Well, most of them will. Yeah, if you are looking to enforce your mark in the United States, that the defendant is located elsewhere is irrelevant. You can get the courts, you can get Customs and Border Control. You can enforce your mark in the United States, within the United States, with the U.S. court, regardless of where the defendant is located, as long as they are pushing their mark or marketing themselves within the United States. I mean, to the extent that Vox may only be marketing in some other place, which I mean, the fact that I can see his stuff here when I'm searching on the internet at a .com website, I mean, is unlikely. But it, you know, sure, you can't stop him from publishing in China with the U.S. court, but you can stop him from publishing in the U.S. with the U.S. court, and it doesn't matter where the.
And to be clear, Ethan wouldn't have to pay Vox's European attorneys for the enforcement.
No, there's no reason to get any European attorneys involved, unless you wanted to. I mean,
that's some expensive pro hack vice counsel. Okay, so that's the factors here, guys, and I wanna wrap this video up. We're only an hour longer than I thought we were gonna be, but that's okay because these issues take time; they take fleshing out. So thank you for bearing with us through this, and let me kind of start to close it out. And Stephen, if you've got anything, feel free to jump in. But one, it's important to note that under the law, the legal reality here is that Ethan Van Sciver, from the facts that we've seen, which have yet to be countered by anyone in any substantive way, that to me at least, Ethan Van Sciver has an enforceable common law mark probably already. That if he wanted to defend that mark against Vox Day, theoretically he could take him to district court and ask for an injunction against the shipping of Gun Ghoul with that imprint on it. In theory, he could do that. This would be expensive. Trademark litigation is an expensive process, but it's important to know, because sometimes you got to understand, like Vox is making very significant claims about what Ethan can and can't do. Ethan very likely has an enforceable common law mark. He certainly has a good faith claim to a common law mark at this point. And that's a really important thing. Litigation on this issue would not be frivolous. In my opinion, I think he'd be likely to prevail based on the facts that we've discussed and that we've seen. I don't know. Are you of a similar opinion to that, Stephen?
Everything I've seen, I would agree. I think he has a very good claim, and I think given the facts we have, he has a very high likelihood of success.
Right. And I want to point out before anybody jumps in, Ethan has said stuff like ComicsGate is for everyone. You're the leader of ComicsGate. Everybody's the leader of ComicsGate. This isn't really relevant in a major sense to the trademark question. Ethan has not said you have a right to use ComicsGate, the trademark that I have on my channel. He's not licensing that trademark out. He's just making statements about the movement of ComicsGate, which is separate from his trademark, and are not going to be really they might be some sort of minimal factor in a court case, but they're not going to weigh in heavily unless we're talking about lines of trade. All right. And that sounds a lot like corporate puffery. A lot of corporations try and develop a culture around their brand. Look no further than Apple, right? Like, who is defining Apple? You are. All this type of corporate speak is very common. Ethan is very good at it, but saying that people are driving the brand or people are driving the movement doesn't actually grant legal ownership to the movement. So I want to be kind of clear on that. However, all of that said, there's legal reality and then there's practicality. And the practical aspect of this is if Ethan wants to enforce this mark, he probably can, but he needs to do a massive cost-benefit analysis on it. He needs to determine if it's the right move from a PR standpoint. He needs to determine if it's the right move from a fiscal standpoint, because like I said, it's very, very expensive. But if he wants to hold on to the ComicsGate brand, if he wants that to be something that he has ownership of, ComicsGate Live, ComicsGate, promotion of comics, stuff like that, then he does need to enforce it. Because Vox is right in one respect. It can get to dilution if he lets other people use the mark without either specifically licensing them the mark, or without fighting against people that he doesn't want to use it. So, in any of these legal questions, you have the legal reality, you have practicality. This is one that might actually come out in favor of pursuing that legal reality, because Ethan Van Sciver's books are selling massive amounts. ComicsGate artists, the ComicsGate artists who are creating stuff are doing $50,000, $85,000, $100,000 single edition books. I mean, we're talking terrific and tremendous financial success for these guys. So holding onto that brand may be of value to them. But defending this stuff is no joke. It is not cheap. And so that's a conversation that he'd have to have with competent counsel. But it's important to know that what Vox has done here is not harmless. It is not lawful. It is likely infringing on a trademark owned by Ethan Van Sciver, and it's up to Ethan to decide whether or not he wants to defend it. So those are my closing thoughts. I'll give you the last word on any of this legal stuff if you got anything. But
I just think it's important in general for everyone to kind of realize the limitations of their knowledge. That Vox Day is potentially smarter, more intelligent than I am, most likely. But that he knows more about trademark issues. I mean, it's one of those overstretching that not just him, everyone does. And when you're interfering with someone's livelihood, and you just mentioned a lot of very high dollar numbers, it may be worth, a second opinion, maybe a more informed opinion before you start doing that, because people have a lot to lose. And, if you push someone in a corner, they may need to react. And, your internet comments and your, internet legal degree may get you in a little bit more trouble than you'd want them to.
That's been one consistent thing I've found with comics professionals is all of them seem to be legal experts. It's amazing. They all know everything about copyright. They all know everything about trademark, and any other legal issues, especially things like RICO and.
Never RICO.
I'm looking at you, Jamal Eigel. I'm looking at you, buddy. You should come on my stream and debate legal topics with me. I think we'd make a fortune together. I'd split it with you. Anyway, I think that wraps this up. Stephen, I want to thank you so much. If you could once again say your firm name, you do intellectual property stuff. What else you do? Just go ahead and plug the heck out of yourself.
Intellectual property, any sort of government regulatory issues, you can your firm. It's Smith Law TLH, as in Tallahassee. We're located in Florida. We've got offices in Tallahassee and Melbourne. If you have any issues, please feel free to look me up, give me a call. I'd love to talk to you. Man, all right. And thank you. It's always a pleasure getting to talk to you. It's always fun.
It's best when you get to practice law with whiskey, right? Like that's the
it's the best. It makes it tolerable.
All right, man. Well, thank you so much. I'm going to go ahead and stop recording on the video here. Thank you all for watching. If you have feedback or questions, drop them in the comments. Hit me up on Twitter or whatever. You can find all my stupid social media stuff. And again, if you've got real legal problems involving intellectual property or other government regulatory stuff, I know some of you guys out there are going to be guys who are either in the comics field, who are looking to get into the comics field, who are publishers, stuff like that. And you've got some questions. If you need some advice and competent direction, contact Stephen. contact his firm and see if they can help you out, or at least point you in the right direction. Anyways, guys, thanks so much for watching, and I will talk to you soon about this stuff, and stay tuned, of course, for more hilarious content. Thanks.